Hey guys, today we're going to talk about termination clauses. A termination clause is a provision in a contract that outlines the circumstances and process by which either party can end the agreement. Without this clause, terminating a contract could lead to legal disputes and financial liabilities. It helps manage expectations, protects both parties, and provides legal clarity when a contract needs to end. A well-drafted termination clause sets out clear conditions under which an agreement can be lawfully terminated without breaching contractual obligations. There are different types and permutations of termination clauses, each serving a unique function depending on the nature of the contract. One common type is termination for convenience, which allows one or both parties to terminate the contract without citing any reason. This is frequently used in commercial agreements and employment contracts, typically requiring advance notice such as 30 days, 60 days, or 90 days. Another type is termination for cause, which is triggered when one party fails to fulfill their contractual obligations. That is called cause, C-A-U-S-E. This is commonly found in employment, franchise, and supplier agreements, and usually specifies what constitutes a material breach, which allows for termination for cause. Automatic termination clauses are also widely used, where a contract ends automatically upon a specified event, such as bankruptcy, force majeure, or the death of a key party. This prevents unnecessary legal disputes. In some agreements, termination by mutual agreement is an option. That means both parties have to agree to end the contract before its completion. Termination by mutual agreement is often seen in joint ventures, partnerships, and business collaborations, and typically involves settlement terms to ensure that there are no legal claims after the termination. Some contracts also include termination with liquidated damages, where a party is allowed to terminate but must pay a pre-agreed sum as compensation. This is common in construction and real estate contracts, ensuring that the other party is not left at a financial disadvantage. Under Singapore law, termination clauses operate within the framework of contract law principles and statutory regulations. Singapore follows the principle of freedom of contract, meaning parties are generally free to agree on their own termination terms. Singapore case law also plays a role in interpreting termination clauses. Courts will generally uphold such clauses if they are clear, reasonable, and do not amount to an unfair or unconscionable contract term. In certain employment cases, excessive notice periods or termination penalties have been deemed unenforceable. The key takeaway is that termination clauses must be reasonable and clearly drafted to be enforceable under Singapore law. Termination clauses are crucial in contractual agreements as they provide legal certainty and help parties mitigate risks. Proper termination clauses protect businesses from wrongful termination disputes, while fair clauses ensure that employees or other contractual parties are not left without recourse. Poorly drafted clauses, on the other hand, can lead to costly legal disputes, especially when termination involves compensation, restrictive covenants, or confidentiality obligations. This highlights the importance of ensuring that termination clauses are clear, reasonable, and tailored to the needs of both parties. To illustrate how termination clauses operate in real-life situations, consider three common scenarios. In an employment contract, a termination for convenience clause may allow an employer or employee to end the contract with 30 days notice. If the company decides to restructure and terminates an employee's contract with notice, the employee cannot claim wrongful dismissal since the termination was conducted in accordance with the contract terms and for the genuine purpose of restructuring. Second scenario, in a supplier agreement, a termination for breach clause may state that if a supplier fails to deliver materials on time twice in 6 months, the client can terminate the agreement immediately. So, if the supplier misses 2 deadlines, the client can lawfully terminate without further legal consequences. Third scenario, a travel contract may include an automatic termination clause due to force majeure. stating that if an uncontrollable event, such as a natural disaster, makes operations impossible, either party can terminate without liability. If a pandemic forces a luxury resort to shut down, the force majeure clause allows termination without either party being responsible for damages. Termination clauses play a critical role in contracts by ensuring clarity and providing a structured way to end agreements without unnecessary disputes. Whether it's for convenience, for breach, automatic termination, by mutual agreement, or termination with liquidated damages, having a clear and enforceable clause prevents misunderstandings and legal conflicts. Anyone entering into a contract should carefully review termination clauses to ensure they comply with the law and to protect their interests. Thanks for joining me in this discussion on termination clauses. Don't forget to like, share, and subscribe. I'll see you in the next video.